Good evening. Welcome to our International Speaker Series. My name is Angela Zhang. I'm the Director of the Center for Chinese Law at the University of Hong Kong. Today, I'm very pleased to introduce Mark Jia to our workshop. He is currently a fellow with Harvard Law School's East Asia Legal Studies program, and he will soon join Georgetown University Law School as Associate Professor of Law. Mark writes on courts, procedure, and public law with particular focus on China and the United States. He previously served as law clerk to two U.S. Supreme Court justices, including Justice David Souter, Justice Ruth Ginsburg, and also the Judge William Fletcher at the Ninth Circuit. He is a graduate of Princeton, Oxford, and where he studied as a Rhodes Scholar and Harvard Law School. And he also served as an article co-chair of the Harvard Law Review. So I have to say that even before Mark officially started his academic career, he already done extremely well. Now we have a discussant, Jack Cronkey, a recurrent discussant of this speaker series. I'm extremely grateful for his participation. He's currently Associate Professor of Law at our law school, and he graduated from Yale Law School and also holds a doctoral degree from UC Berkeley. So Jack research focus on a wide variety of topics, right? International comparative legal history, as well as law and political approaches to labor and property law. And he currently teaches property, equity, and trust at our law school, as well as some common law courses for civil law students. So without further ado, let me give the floor to Mark.
Great. Well, thank you for that kind introduction, Angela. It's a tremendous honor to take part in this event with HKU. I know you've had just a really wonderful set of remote conversations at the center in recent months, and I very much appreciate having the opportunity to engage here as well. And also a special thank you to everyone in Hong Kong who is joining me on a Friday evening. I'm sure there are far more exciting things you could be doing with your time, but I very much appreciate your interest in my work. So to start the talk, let me first share the PowerPoint. There we go. So my aim today is to go over a paper I published about a year ago called Illiberal Law in American Courts. The basic aim of that paper is to set out what happens when American legal institutions, and in particular courts, encounter the legal systems of authoritarian countries. My basic argument is that the laws of authoritarian countries can be uniquely challenging for US courts. Such laws, I contend, can present special interpretive problems outside of those we typically associate with the interpretation of foreign law. My aim in this paper and in this talk then is to map out what is distinctive about authoritarian laws in this context, and to understand some of the many ways in which US courts have sought to address these challenges in recent years. Now, before proceeding, I should say that although my focus here is on what is happening in US courts, the laws of authoritarian countries arise in different courts and arbitrations all around the world. Many of the issues I address today likely have much broader applicability than what I'm focusing on here. So please bear that in mind. Please bear in mind that my emphasis on the US offers just one case study in mapping out an issue that I think extends far more widely and deserves much wider treatment. So my plan is to present my work to you in three parts. And these parts essentially track the three major substantive sections of my article. So in part one, I'm going to provide a brief descriptive account of the state of authoritarian law adjudication today and in the recent past. Here, I will highlight the relevant countries, cases, and some of the legal doctrines that are often at play here. In part two, I'm going to explain on a more conceptual level why it is that foreign authoritarian laws have been especially challenging to interpret or evaluate in US courts. And here I'll focus on challenges having to do with those laws themselves and those institutions, and also having to do with those who are interpreting the laws. And in part three, I'm going to explain how US courts have sought to address these challenges. And I'm going to catalog what I see to be some of the trade-offs between varying approaches before suggesting the contours of a modest way forward. So start with description. How is it that foreign authoritarian laws find their way into US courts? How often do such encounters happen? And which countries' laws tend to arise most often? So for those attending with a law background, you probably already know that although US courts are accustomed to interpreting US law, they are on some occasions also asked to construe the laws of foreign countries or to assess the fairness of foreign countries' legal systems. So this can happen as a result of many different doctrines that deal in foreign law, from basic conflict of laws principles in civil cases to special doctrines of family law or immigration law, to more what I see as more evaluative doctrines like forum nonconvenience and foreign judgments recognition that often require US courts to decide whether a foreign legal system is fundamentally fair. So to take the simplest example, if two companies enter into a commercial contract and agree that UK law will apply, and if a dispute eventually arises under that contract and the parties go to court in the United States, that court will likely apply UK law unless it has very good reason not to. Or to take another example, if one party wins a judgment against another party in French court, but the losing party holds its assets in the US, the winning party may try to get at those assets by asking a US court to recognize and enforce the French judgment here in the US. The losing party can defend against this in a US court by arguing that the French legal system is not fundamentally fair, or by asserting that the specific proceedings that gave rise to the French judgment were unfair. And if a US court agrees with this argument, it can, and in some cases must, refuse to recognize and enforce that French judgment. Now, for a good deal of American history, US courts engaging with foreign laws were mostly dealing with legal systems like those found in the UK and France. In other words, US courts were mostly engaging with like-minded legal systems, where as a general matter, there was less philosophical uncertainty about where to look if one wanted to know what the laws were or how they might be applied. Now, over the past few decades, much of this began to change as globalization began linking more and more actors from a greater variety of different regime types. US courts have had to increasingly adjudicate disputes involving the laws and legal institutions of non-democratic countries, countries for which they have often been less able at times to assume adherence to what you might think of as rule of law principles that we often associate with modern legal systems. So for a rough sense of how cases involving many authoritarian countries have increased over time, consider the following chart. So here on the horizontal axis, we have successive 5-year periods as a measurement of time. And on the vertical axis, I have an estimate of search hits taken from Westlaw in, I think this was in 2019. I won't go right now into the details of each search string I used to produce these search hits, but suffice to say for now that they were designed to very roughly approximate, at least for comparative purposes, how often the laws of a particular foreign country arise in US courts. So the trend on this slide summarizes what the trend line has been for 3 authoritarian countries over the past several decades: China, the combined USSR and Russia, and Saudi Arabia. And as you can see, caseloads have increased for each country over time, but none more rapidly than for China. And for that reason, among others, a lot of my discussion here today will focus on the subject of Chinese laws as they arise in US courts. The next chart here displays the authoritarian countries associated with the highest number of search hits in Westlaw. Here too, you see how China leads the pack in overall caseload by a fairly substantial margin, in fact, followed by countries like Turkey, Russia, Cuba, Iran, Saudi Arabia, Venezuela, and Singapore. Now, on some level, these results are not surprising. The countries that top these lists tend to be important geopolitical and economic players. They and their people have significant business relationships with American and multinational entities, and their citizens frequently travel or emigrate to the United States. These and other touch points set the stage for a variety of disputes that may eventually find their way to court. And when they do, I think the results can be quite interesting. So if we take the example of China, and please excuse this not very reader-friendly slide, you can see how in recent years, US courts have had to engage with Chinese laws involving a truly wide variety of subjects. So I list some of these subjects here in my piece. They include laws involving arbitration, banking, competition, contracts, corporations, criminality, export, family relations, foreign exchange, foreign investment, jurisdiction, privilege, procedure, securities, service of process, state secrets, tortious conduct, and intellectual property. Both the breadth and depth of engagement here then has been quite significant. So turning now to my first argument, I want to suggest in this paper that in these encounters I've documented so far, the laws of authoritarian countries can be uniquely problematic. That is, authoritarian laws can pose special interpretive challenges to US courts distinct from the problems associated with the interpretation of foreign law as a whole. So to build this argument up, a basic presupposition I have here is that when a US court considers foreign law, that court tends to assume that whatever the differences the foreign legal system in question contains, that whatever the differences the foreign legal system in question contains in a very minimal sense, laws and legal institutions that conform with modern assumptions about legality. So in this modern paradigm, law consists of written rules enacted by state authorities pursuant to recognized procedures. These laws are generally public, prospective, understandable, stable, and they're enforced by impartial decision makers applying specialized legal reasoning. What's more, these assumptions about legality are assumed to apply to a variety of different legal systems. In the paper, for example, I document how a lot of central comparative debates about differences between civil law and common law may rightly point to many distinguishing features between the two systems. And yet in both cases, there's always an assumption that this basic minimalist paradigm about law, what we might think of as modern legality, holds true. We can speak of different approaches in civil versus common law, but still assume that basic legality holds. Authoritarian legal systems, however, have a systematic tendency to depart from these minimal assumptions about law. So, for example, many autocratic legal systems often feature documents that present to the world as laws, but are in practice not at all enforced. So an extreme illustration of this is the North Korean constitution, which promises freedom of speech, press, and assembly, among other rights, but which in practice guarantees none of those things. Sham laws of this sort can exist not just in the realm of constitutional law, but in all kinds of civil and criminal domains. So how does a US court treat documents like these, which, although they contain the trappings or the features of legality, are essentially sham, right? Like, should US courts pretend that such documents are law, or should they refuse to credit such texts as law, even if foreign governments project to the world that such laws are in fact real? What is the proper judicial role in such cases? Now, a second way in which authoritarian legal systems can depart from modern legality is that there can exist certain norms or commands that, although they lack the traditional features of legality, nonetheless regulate conduct with something resembling the force of law. So for an example of this phenomenon, which I call hidden laws, consider the following quotation from an expert witness in a US-based antitrust action, who was asked to describe this particular aspect of China's legal system. Quote, "Many official requirements are transmitted through communications that may consist of department documents or oral directions, even including telephone calls. It is not the form of communication that creates its binding character, but the source and authority of the party giving the direction. Regardless of form, to the extent that these directions come from people in superior authority, they are no less binding and obligatory on subordinates in the companies than any other type of law." So with sham laws, hidden laws of this sort pose special interpretive problems for US courts. For example, when, if ever, should a US court recognize an unwritten prescript as law? Can oral commands be law, at least in some circumstances? And what about regulations issued by a political party as opposed to regulations issued by the state? What about regulations that are jointly issued by a party and the state? Are there circumstances when a US court ought to recognize even those prescripts as law? Now, a third way in which authoritarian legal systems challenge prevailing legal assumptions is that authoritarian courts are sometimes not really like courts the way we might think of them here. Instead, authoritarian courts can more likely be subject to political or party instruction or expectations. And in this way, such courts can systematically depart from our baseline assumptions about courts in this kind of modern legality paradigm as impartial arbiters that make decisions on the basis of specialized legal reasoning. Now, this can introduce many thorny questions as well. So most basically, how should American courts treat legal systems where judgments are often rendered under extrajudicial pressure? Should they assume impartiality even in the face of contrary evidence? Questions like these also, I would contend, deserve careful attention and consideration. A fourth complication here is that authoritarian legal systems, especially today, might be described as bifurcated or dualist to some degree. What this essentially means is that in certain areas, including commercial law, intellectual property, routine civil disputes, you might expect courts to work in ways that largely conform, at least superficially, to modern legality, at least where sensitive local or central interests aren't at play. What I mean by this is that the laws in those domains will be largely public, prospective, and clear. The courts will more or less apply them in a faithful way. And a US court applying such laws, too, might have no problem doing the same. But in other domains that touch on more sensitive issues or interests, you might have laws that remain hidden or sham, as I've defined them, and courts that cannot be expected to reliably apply what appear to be authoritatively written laws. So for American judges, such bifurcations present vexing problems. How do judges distinguish between features of authoritarian legal systems that actually adhere to modernism versus features that only do so superficially? Should foreign law interpretation itself be bifurcated with more skepticism towards judicial decisions in non-commercial areas of law? Should foreign law evaluations be similarly bifurcated, with courts more willing to recognize judgments or dismiss for form nonconvenience in certain sectors of foreign law compared to other sectors? Now, a final way in which authoritarian laws can be distinctively challenging the US courts stems not from any features of authoritarian law itself, but from potential biases that US courts might have about authoritarian legal systems. The concern here, to be sure, is not that US courts will correctly recognize departures from modern legality where they exist and are before the courts. I've done a lot so far in this presentation to point out such departures. The concern rather is that a US court might assume, without specific evidence before them, that a particular authoritarian legal system works in a particular way merely because it is authoritarian. So I think of this as almost a kind of authoritarian stereotyping. And it's something that has come up occasionally in the US. So I found appellate cases where courts have reversed or vacated lower court or agency decisions because the appellate court has claimed that the lower courts or agencies relied on stereotypes about how authoritarian legal systems work, instead of actually looking at the evidence before them about how that particular system worked. As many of you know, there are many different kinds of authoritarian systems in the world, and they don't all work in precisely the same way. So given especially that American self-identity is in many ways based on a kind of anti-authoritarianism, right? A sort of anti-fascism, anti-totalitarianism. It makes sense that this could also be a potential issue that could inhibit accurate interpretation of foreign law in US courts. And I would say that this too raises a number of important and thorny issues. So first, how can courts realistically check anti-authoritarian biases if they exist? Is neutrality even an achievable ideal? Or conversely, is it even desirable that courts police such biases at all? Might treating all authoritarian laws as something less than law, as former law professor Anne-Marie Slaughter once advocated, instead promote other normative ends in law and in international society? So in my review of case law, I found that US courts have tended to approach the problems of authoritarian law in two very different ways. The first method, which you might call a kind of formalism, treats as law all traditional sources of written laws within what we might think of as modern legal systems: constitutions, statutes, regulations, and where relevant, judicial decisions. The fact that a legal document may be unenforced in practice or ignored as law by local legal communities would be interpretively irrelevant, so long as the traditional trappings or features of legality are there. So returning to this quote I put up earlier from the Chinese law expert, a formalist would look at this quote, and a formalist would not be at all inclined to credit an oral directive as law, no matter how a foreign law expert attempts to paint the Chinese legal system as distinctive in that particular way. In fact, in that very litigation, the district court judge refused to credit the expert testimony. He instead focused on what he called, quote, the traditional sources of foreign law, end quote. And by that, what he essentially meant was he only cared about written, statutory, or regulatory sources and their plain or ordinary meaning. On the other end of the spectrum, some judges have instead chosen to look past legal formality and to focus more on law as locally understood. So you might call this a kind of functionalism, a term that is often used in comparative law scholarship, because the emphasis is on function over form and on facts and local context over an isolated kind of legal reasoning. So to get a flavor of what functionalism might mean in practice, consider the following quotation from a district court judge in New Jersey in a very similar case, also involving Chinese exporters. Quote, "The court finds plaintiff's position that in order to be real law, a mandate must be reduced to a written statement issued by a government unduly condescending toward foreign legal regimes structured differently from the system used in the United States, Europe, or akin. Many provisions are treated as law regardless of the fact that the delegated authority of the authors is not or cannot be established," end quote. So in this way, you can see then how whether judges have formalist or functionalist tendencies can profoundly shape what ultimately gets regarded as law. And that in turn can determine whether a party wins or loses in court. It can be that important. And I would contend that in this pair of cases, it was that important. So differences between interpretive methodologies aren't merely intellectual or theoretical. I think they can have real practical consequences too. Now, in comparing these methods, formalism on the one hand and functionalism on the other, I think it's easier to speak of trade-offs than of one method being in all ways superior over the other. Indeed, each method I've identified here has its share of advantages and disadvantages. So begin with functionalism. Functionalism is generally more accurate, I would argue. That is, it is better in getting foreign authoritarian law right. A strict formalist might apply the Chinese Constitution because that document would appear to bear all of the hallmarks of modern legality. And yet, in a number of cases, that would be an odd outcome, given that Chinese courts are not permitted to apply and enforce the Chinese Constitution. But there are cases where US courts appear to have treated China's Constitution as law like any other, indeed fundamental law, without acknowledging any of these additional complexities. At the same time, formalism has led to inaccuracies in the foreign law evaluation context too. So in one noted case called Tong versus Sinutra, parents of children who had ingested tainted milk products in China brought suit against the Chinese producer's US parent corporation in federal court here in the US. The defendants moved to dismiss for forum nonconvenience, basically arguing that the claims should be heard in China and not in the United States. Now, in response to this motion to dismiss and to prove the futility of litigating the case in China, the plaintiff parents in this case offered declarations from several Chinese lawyers who had repeatedly tried but failed to convince local courts in China to accept their complaints. The US District Court nonetheless deemed China an adequate forum and dismissed for forum nonconvenience. And the court relied on a declaration from the Supreme People's Court stating that Chinese courts were ready to process civil lawsuits for tainted milk cases. So was the court right to do this? I would argue no. As I see it, the far more specific affidavits describing a different reality on the ground should have superseded any kind of formal pronouncement from the Supreme People's Court, at least as a matter of US law, where the kind of core practical question that courts ask in a forum nonconvenience motion is, are there adequate remedies in the foreign forum? And here you had specific evidence that local courts simply weren't taking these cases, notwithstanding what the highest court in China had said. So as a result here, I think I would argue that the district court here mistook formality for truth. While functionalism is generally more accurate, I think it can also be less practical and more resource intensive than formalism. US judges simply can't be expected to know the nuances of every foreign legal system. And indeed, not all parties have the interest or the funds to hire foreign law scholars to serve as expert witnesses. What's more, in a great many cases involving authoritarian countries' laws, especially in non-sensitive civil disputes, formalism might be enough in the sense that the laws may be more evenly applied in those particular areas of law. So compared to functionalism's accuracy-related advantages, formalism might be said to offer a kind of heuristic usefulness in many cases. Finally, I should add that formalism and functionalism also implicate different constraints that inhere in the judicial role. So for those who think judges have an expressive obligation to convey certain principles about legality, to shape public norms about law, functionalism might seem to signal an abandonment of that ideal, right? It might seem to signal a concession that what constitutes law is a more malleable thing. On the other hand, a strict formalism that refuses to credit as law anything that doesn't resemble familiar structures in American law might be assailed for failing to extend appropriate comity to other nations. So in the last quotation I shared here, the judge made a really similar point, asserting that a refusal to credit unwritten prescripts would be unduly condescending toward foreign legal regimes. And I think it's fair to say that formalist methods, both in comparative law and also as I've defined them here in the foreign law interpretation context, can sometimes carry a subtle sort of universalism to them, right? A sense that your law must in all ways resemble ours, or else it doesn't count as law at all. And for reasons of not just accuracy, but also institutional competence and separation of powers, some might argue that American courts should not be engaging in that kind of thinking or reasoning either. So where does all of this leave us? Well, I don't purport to have all the answers, but I think there are a few things US courts can do to better meet some of these new frontier challenges posed by authoritarian legal systems. The first, I think, is just to recognize that this is a distinct problem with its own distinct pathologies. In my review of case law, I found that many judges seem to assume, as a matter of course, that courts or laws abroad work in largely the same way they do in the United States. And one of the aims of my research is to say, well, no, there are special problems associated with non-democratic legal systems that deserve careful study and attention, certainly a lot more so than there has been in the past. The second idea, as I see it, is to embrace a principled sort of functionalism as much as possible. In the end, accuracy, the goal of getting foreign law right, is the most fundamental value underlying judicial interpretation of foreign law under US federal law, and in particular, Rule 44.1 of the Federal Rules of Civil Procedure. And accuracy when it comes to foreign authoritarian laws might mean having to put aside some of our assumptions, not all of them to be sure, but some, about how law works and what its authoritative sources are in other very different jurisdictions. But that said, one can also imagine, hypothetically at least, a more freewheeling sort of functionalism where a willingness to look past legal formality leads American jurists to confuse law with what are actually efforts to subvert law, right? Because it certainly can't be the case that all things are law either. Just because a party leader makes a statement does not make that statement automatically law. So to go down that path would be a mistake too. And I problematize this a bit more conceptually in the article. Now, to aid courts in this endeavor of achieving a more principled functionalism, I think it would be especially helpful to find more creative ways to involve expert witnesses who can play a quite vital role in unsettling false assumptions about that US judges may have about foreign law. I want to learn more about this. I know less about this than I should, but I've always been drawn to the way more inquisitorial legal systems deal with this problem, which is to make use of court-appointed foreign law experts rather than to rely on the adversarial process. And even though sort of dueling adversarial experts are the norm in American law, it actually is permissible as well for US courts to appoint experts too, including in the foreign law interpretation context. I'm not the first to suggest this, to be sure, but I would hope that my work highlights a more urgent need to pursue these kinds of reforms. So I should end with the final caveat, which is to say that while I focus my talk on ways in which authoritarian legal systems depart from modern legality, I do not at all mean to suggest that American law represents a perfect embodiment of those principles either. Judicial corruption, for example, has historically been a fairly significant problem in US law and US courts, especially in certain state courts. What I do maintain, though, is that there is a distinct logic to authoritarian legality that makes some of the departures I've spoken about above, things like hidden law, sham law, and so forth, a consistent feature of many authoritarian legal systems. And it is those features in particular that have vexed and are likely to continue to vex US courts in the years to come. So I think I'll stop here in the interest of time, and I very much look forward to the ensuing questions. Thank you very much.
Thank you very much, Mark. I really enjoyed this presentation, and also when I was reading this paper, I really like it because I think it's very practical, and I also have, because it's going to have great relevance for courts when they decide how to deal with those potentially conflict with law issues. And most importantly, your proposal of having more expert witness, potentially, Chinese law experts, right? I mean, so create a lot of business opportunities for us. So I think it's important that we highlight this scholarship. So now let me introduce, let me give the floor to my colleague, Jack, to give his feedback on this paper.
Okay, great. Thank you, Angela. Well, Mark, thank you so much for presenting this. And I think the paper makes a really valuable presentation, in large part because it's something that's often discussed in the abstract, but actually specifying the scope and actually seeing the case law, right, put it in one place, I think is a valuable resource in and of itself. But I'm just going to provide three provocations, one conceptual, one institutional, and one normative, right? On the conceptual level, I really wonder, now that you saw the paper's been out for a while, it's something you've been thinking about, how much you're really wedded to the work that authoritarianism does. So even in the paper, right, you shift around a little bit your definition. There's a super legal decision maker, there's an anti-accountability norm, and I think here you actually use non-democratic much more than you did in the paper, right, as a way of designating what's authoritarian and what's not. And you acknowledge that this is a spectrum, but I think because of the bifurcation issue in the economic realm, which a lot of these cases are, it makes it really difficult to see where the formalism, functionalism sort of approaches really deviates in kind, or really that strongly from what we would see if we just looked at this more honestly in other contexts, right? You talk about the anti-authoritarian bias, and I think a lot of times judges just have a heuristic, right, about which countries have good law and which countries don't have good law. And I, often hear from civil law scholars working on international forums or in other contexts, the overconfidence of common law lawyers, right, and thinking that they can understand civil law and that those things are so easy. And in particular, if I look at the specific logics of sham laws, hidden laws, and political courts, I think almost any deep level of knowledge about the enforcement of law in any legal system is going to touch on these things. And the two examples that jump to mind is Japan from the 1980s, right? Almost everything you just said, people said about Japanese law in the US, and as far as like not understanding the law being the law, there being politicized courts. And ironically, Japan said much of the same thing about the US legal system, right? They said it was essentially many sort of comments about it being like a non-tariff trade barrier because of its complexity and the fact that it didn't match like the law that was on the books from their perspective. And in the contemporary context and thinking through authoritarianism, I think about the one place that stands out the most under sort of like polity Westlaw search is Singapore, right? I mean, Singapore, do people even raise this question about Singapore? It's very high on authoritarian sort of scales by some measures. It's very active, but it doesn't seem to be controversial. And Hong Kong might similarly, right? These are common law jurisdictions where perceptions of these things might change, right? So rather than evidence, it really requires some sort of direct disruption of the heuristic that people have to really look at the evidence. And when they look deeply, they see complications, right? Now, that may be a scale, but if I think about like employment law in Europe and other democracies, in some ways, I can predict what's going to happen in the employment law courts of authoritarian regimes better than many of those democracies, right? So I just want to, there's a lot of discussion these days about authoritarianism as a regime type sort of predictor and sort of how strongly do you still feel about that. I think the second and most natural question is about judicial capacity, right? So I think you sort of touch on this in a way, you're asking judges to do the impossible, right? I think you say that judges are not sociologists nor comparativists, nor they should be, right? I think that's a little bit more of a contentious point. I think a lot of people, when we were having this sort of, foreign law and Supreme Court jurisprudence debate, had a lot of ideas that they should become comparativists. And while I keep trying to escape them, you do mention Roscoe Pound. Right. So when you talk about Roscoe Pound's sociological jurisprudence, he had an idea that he wanted there to be a ministry of justice, actually, as he saw in other countries, because he wanted this ministry to produce empirical data about the real world that then judges could use as part of his sociological jurisprudence. And his big split with progressives and the legal realists, so they thought judges couldn't do this, right? This is where administrative law should step in. So you sort of proposed the continental system, sort of like experts brought in, right? And maybe from panels, right? So they have ways of doing this where it's not on an adversarial basis. But why not just go to a full sort of a proactive administrative regime that evaluates legal systems, right, outside of the heat of particular moments and provides sort of sustained research where you get an administrative determination, right? That creates like a rebuttable presumption about what judges should be looking at, right? So that they don't have to go into all of this, right? And it can be a much more transparent and open debate. And for partners like China or other countries that we're deeply economically integrated with, right, this proactive is a much better than the sort of typically ex post judicial sort of reaction to this. And I think this opens up really fascinating for the comparative terrain, as you mentioned. There's lots of other places that deal with these issues, right? And how do they sort of confront them? The normative is more getting at, I was thinking about Diego Zambrano recently published this piece about dictators in American courts. You probably saw this, right? Where it's pretty straightforward, where we don't want dictators using our courts, right? And he uses, China as an example in a variety of contexts there. And so before jumping to sort of the big normative questions, I wonder about like the litigants, right? I mean, if an administrative sort of body can create these rebuttable presumptions, we can also assume that you mentioned in the paper, not wanting to incentivize people who know they have sway over courts for choosing them, but it seems like we're erring a little bit on the other side, right? These are generally sophisticated commercial actors that we're dealing with. And there should be some sort of assumption of risk, right? You don't get bailed out ex post because you engaged in something that you knew might be problematic, right? So I wonder if there's any sort of utility, as you mentioned, in really sort of differentiating the litigants, right? Someone who voluntarily engages with a foreign legal system versus someone maybe through a divorce proceeding, family law, et cetera, where it's involuntary, right? So we maybe don't even allow the profit-seeking actors to rebut the presumption, but we would allow someone to rebut a presumption who comes in contact with the system, not of their own free will. And maybe that's just doctrinal revision. So the larger normative question then, this is more sort of the Zambrano sort of idea, right? Is that, as the world sort of becomes more authoritarian, I think is sort of the general trend, right? All these, I think in the paper, right, you mentioned Russia as being non-ideological authoritarian, China a consultative authoritarian regime. And I wonder, given the last year, right, how stable some of these categories are, how people feel about the US, like you mentioned, right? I mean, there are parts of the US legal system, it's not just sort of like episodic corrupt state courts, right? Currently have debate. We have the most unaccountable federal sort of judiciary on the planet, right, by any stretch of the imagination. So, I wonder if people start sort of looking at access to justice or some other way of really sort of establishing this, you might have something that's a little bit different than regime type, right? Or even some sort of more politically charged idea. There's got to be some other rubric that sort of like gets at this in a way that serves the sort of public law aspects or maybe the expressive law aspects while also not disrupting the sort of the commercial aspects. And I also wonder though, sort of on a more cynical side, whether or not what you're really looking at in this context is the sort of, given the anti-authoritarian ideal of the United States, right? Again, how much that survived in recent years is up for debate, but we've sort of backed ourselves into a corner, right? We've created a global economic order where engagement with authoritarian regimes is far more routine than it was during the Cold War or during potentially other eras of time, right? If we actually had an aggressive, like an administrative body doing these determinations, we might cause lots of problems for how the world actually functions, right? You talk about comedy, right? If we actually are accurate in this assessment, we might have huge comedy issues with not just China, right? But maybe a whole range of other potential democracies. And so that would then lead to Zambrano's point that basically we shouldn't be doing anything that incentivizes the current state of affairs where this sort of freewheeling interaction with authoritarian regimes has become the norm, right? So we're not having to ask these difficult types of questions where maybe we do draw certain types of lines about the types of actors in which we sort of give these potential rebuttable presumptions to. And everyone else, it's like, well, if you want to do business with a regime that has these types of problems, then you should, we're not going to just sort of bail you out because you're ex post trying to take advantage of this given the original bargain, but that you're engaged in a normatively undesirable behavior. And I think it's sort of hard to get away from all the language that's currently happening about decoupling, right? I mean, this is part of sort of that variance that's happening right now, is people saying on certain normative grounds, right, we just shouldn't have these types of interactions, and then this type of thing only facilitates that, right? So those are sort of like the main sort of like pushbacks, in part because it's such a fascinating topic, and it is something that really, even though there's a lot of civil procedure in here, touches on some of like the larger sort of normative and conceptual challenges of the day. So that's it. Thank you.
Thanks, Jack. Mark, would you like to respond briefly?
Yeah, I'd love to. Thank you so much for using my headphones now. Can everyone hear me?
Your voice is a bit low.
Yeah, I'll take this off.
Now it's better.
Great. Thank you. So thank you so much for those comments, incredibly thought-provoking. I'll take them each in turn. So On your initial question of how much am I wedded to kind of the authoritarianism framework, I think even in the piece, I say that I see kind of my kind of conceptualization of authoritarianism as crystallizing certain kinds of departures from modern legality that even non-authoritarian countries can evince. So you mentioned Japan. I think that's a great example. Mark Ramsayer, for instance, has done work on how Japanese courts and national security cases, state security cases tend to be, unusually deferential towards the state, and you might see that as a particular kind of modernist departure too. But I see these kinds of departures being crystallized, being epitomized in the authoritarian law context, at least in terms of a number of sort of what you might think of as hard authoritarian countries, right? China, Vietnam. If we talk about Singapore, which you brought up as well, I agree with you. The sort of degree of bifurcation or dualism there it is such that in your run-of-the-mill kind of commercial case involving Singapore, these issues really just don't come up. So I think that that's absolutely right. At the same time, I would maintain that there are certain quite distinctive attributes, at least to these hard authoritarian countries I mentioned so far, that you really just don't find in other jurisdictions. So like in recent years, the Communist Party in China has been kind of jointly issuing certain rules or regulations with the state council, right? If this were to come before a U.S. court, I think it would present some real questions in terms of, is this law, is it binding law? Who does it actually bind? These are practices that are fairly distinctive to just single party states. On the question of having kind of trying to delegate responsibility for a lot of these challenges, not to expert witnesses, but to administrative bodies. I think that's a really great idea. To some degree, that is already happening in the sense that if you look at the sources that judges tend to rely on in the US, especially in foreign judgments recognition cases and forum nonconvenience cases where they're asked to assess how fair a foreign forum is or foreign legal system is, they often rely on like State Department country reports, right? Or like State Department travel warnings. And so you look somewhat skeptical. I share your skepticism over that, because those country reports are written for very different purposes, and they aren't really meant to address whether or not an IP case in China, an IP decision should be enforced here in the US. There's a very distinct sort of human rights-based rationale that motivated these country reports to be written in the first place. There was a recent case in New York that where a state court said that not only would it not enforce a Chinese judgment, it said that no Chinese judgments deserve any recognition in the US as a categorical matter. And the only source it relied on was a State Department country report and like a couple of sentences in that country report about Chinese courts. So I think that deferring it to an administrative body could in theory make sense, but you can also see how assuming you don't get an ideal amount of insulation from sort of prevailing political trends, winds, what have you, these bodies might also not be relied upon to be as fair or as comprehensive as we might like. That's not to say the adversarial expert process is perfect either, or even appointing a single expert, but I see that as somewhat flawed too. And as to the more normative questions, yeah. So I enjoyed the piece for foreign dictators in U.S. courts. It was interesting to me how in the piece, the focus was on kind of foreign dictators and their use and abuse of U.S. courts and the asymmetry there. But the kind of all of the policy prescriptions at the end weren't really targeted specifically at only foreign countries, right? I think he recommends sort of a number of reforms, including in including an anti-SLAPP type measure, or that would apply to all countries. It might impact authoritarian countries more, but and I think that makes sense, because there isn't as much doctrinally. There isn't much of a doctrinal hook in a number of these conflicts, contexts, and American foreign relations law, where you can really differentiate countries by regime type. And maybe this also goes to your first point too, which is that there's also this administrability problem too, if you expect U.S. courts to try and make determinations about which countries are authoritarian or which countries are led by single party dictatorships and which aren't, and to apply a different set of legal rules in those contexts. So I think it's an interesting idea to differentiate treatment along those lines, but in a number of contexts, at least, I think it would be quite hard to do as a practical matter.
Great, thank you, Mark. So I also have a couple of reactions when I read your piece. I really like it. Fundamentally, I feel that the piece is dealing with the ambiguity in law, although you focus particularly on authoritarian country. I feel like, look, I mean, when U.S. court deal with a foreign laws, there always, if the law is very clear cut, the practice is very clear cut, there was not this problem. The problem only arises when the foreign law is ambiguous, and the problem just become more prominent with authoritarian countries, because for the simple fact, as you pointed out, there will be sham law, there will be law, there will be legal practice, the informal practices that are not really law, but matters a great deal. And it's overall, for instance, in the Chinese context, informal institutions matter a great deal in terms of how, law is applied and enforced. And that's the reason why I observed American courts have difficulty grapple with the Chinese law, and then need to rely on a lot of intermediaries to resolve this problem. And one of the intermediaries pointed out are the legal experts. I liked your idea of, highlight the importance of experts, although I'm not, super duper optimistic that reliance on experts will completely resolve the problem, because in the adversarial process, the litigants will self-select the experts that they like. And because of the fact that the problem derives from the ambiguity of the law, there's always controversy in the law itself regarding the informal practice, then, there will be a lot of room of argument between the experts, right? So it doesn't necessarily resolve the problem that the court will face. And because of a lot of these cases actually relate to foreign relations, conflict law situations, I wonder, in addition to, these two approaches that you suggest, you mentioned formalism and functionalism, whether U.S. court should take a third approach, which is to deference, the deference approach, like deference to the executive branch, for instance, because in those situations, maybe it's not really about the law, because you are still a very law-focused argument here. But when it comes to foreign relations cases, perhaps U.S. court, particularly when they take the deference approach, is doing it just to maximize their own national interest, whatever it is. And the law then take, a step back. So I don't know how you react to my intuition about this piece. I think it's really important, given how how many cases that we have these days.
Thank you. You can hear me a bit better this way, so I'll take this off. Yeah, thank you. So I share your skepticism of experts in the adversarial context, to have dueling experts. I read my share of forum nonconvenience cases where one Chinese law professor says Chinese courts are amazing, they're perfect. The other says they can't be trusted, they're the worst in the world. And I think that especially in close cases and ambiguous cases, if I were a judge, I wouldn't really know what to do with experts who tend to sometimes take particularly extreme positions in those cases. There have been a few cases in America where courts have appointed an expert. So the judge has appointed a single expert, and in those contexts, you might at least expect the expert to be a bit more even-handed, just because they weren't hired to support a particular litigation position. That this is much more commonly done in civil law countries in continental Europe, for instance, and it's something that is allowed under the federal rules of evidence, but it's just not often done, in part because district court judges in the US have a lot to do, and they'd much rather just let the parties handle fact gathering and what have you. But it's not something that they're legally constrained from trying. And so, if there are ways we can facilitate the use of court-appointed experts, well, whether that means establishing a database of China law experts or Russia law experts that district court judges can easily consult, or I'm sure there are other interesting ideas here. That may be at least one way forward. On the question of deference, I think it's a great question. I see it as kind of applying to like a couple of different institutional actors, right? You can talk about deference to the executive branch, which I think in my exchange just now, we talked a bit about kind of having an administrative authority of some sort responsible for this. I think with the appropriate amount of insulation, that could work, but I'm not sure in that sort of context whether you could have that kind of insulation guaranteed, given how controversial the U.S.-China relationship is, or the U.S.-Russia relationship, or what have you. So I think that would be some concern. There's also a question, of course, of whether to defer to other kinds of parties, non-parties. As you well know, in the vitamin C litigation, the sort of core question that came before the Supreme Court was whether or not U.S. courts should outright defer to the Chinese government's interpretation of Chinese law. And before it was reversed by the Supreme Court, the Second Circuit said yes, right? It said that basically outright deference to a foreign sovereign on their own law was compelled as a matter of international comity. So in that particular case, I think the Supreme Court got it completely right. I think that it makes sense to take into account the kind of comparative expertise that a foreign sovereign has in its own laws. That's certainly something that courts should factor in. But at the same time, foreign sovereigns, when they appear in U.S. courts, often don't do so simply out of the sense of wanting to help U.S. courts, right? They appear because they have particular perceived interests at stake. And so outright deference, blind deference of the sort that the Second Circuit had originally mandated doesn't really make sense either. I think the real question moving forward is, what are the factors that courts ought to assess in balancing, incentives, potentially perverse incentives, with comparative expertise. And the Supreme Court gave some guidance in that opinion, but everything was somewhat vague, as the court tends to be when it first, tries to lay out factors for a new test. And so I think it'll be really interesting to see how the lower courts flesh that particular test out.
Right. I mean, I do recall that in the vitamin C case, even though the Supreme Court did not defer, 100% defer to China, they did quite defer to the executive branch. I remember the DOJ submitted an amicus brief, and the opinion is quite strikingly similar to the amicus brief arguments. So that was a case that I saw that, the court, in this time of ambiguity, court being a journalist, they need to rely on an intermediary. Either could be a Chinese legal expert, or it could be the executive branch, or it could be a foreign sovereign. So a court is choosing among all these. So now we're running out of time, so I really like to open up the floor for Q&A. And you did have some challenge from our audience, particularly regarding the reliance on expert. Richard Wadger did raise a important question. He said, and obviously he seems to study Chinese law for he mentioned he studied Chinese law for 20 years. And he thinks that, US court don't always get the Chinese law right, but that doesn't mean the architecture is not already there for them to do that. And 440.1 is a flexible rule. And he's also slightly skeptical about, he's more skeptical about the so-called experts who choose these people, and how can we be sure that these people are not blinded by political ideology, such as that has been reflecting much of the Chinese law scholarship in the United States today. I don't know if you would like to respond to that challenge, Mark.
So taking the second question first. So, in terms of special panel of experts, I'm not proposing that there be a special panel of sort of experts. And I think maybe this was suggested in our exchange about having kind of deference to an administrative body of some sort. And so, actually, Richard, I share some of your concern that it would be quite difficult to construct an administrative body that could be relied upon to be politically unbiased, especially in the kind of U.S.-China context. So I think that I think we are in accord on that point. And I also take your first point insofar as one of the sort of issues I address in the piece is bifurcation as a reality of many modern authoritarian legal systems. So there certainly are a number of run-of-the-mill cases where things like sham laws, hidden laws, don't particularly come up. They did come up in the vitamin C case. They come up a fair amount in the forum non-convenience context, in the foreign judge recognition context. They come up in the asylum law context as well. I mean, in some ways too, and maybe I'll end on this point. When in U.S. courts we talk about foreign law interpretation, oftentimes we mean two different things, right? One, we mean like, what is foreign law? Like how would a foreign court rule in this particular case on this question of foreign law, of their own local law? And in the other set of cases, we often address foreign law. We often say foreign law, but what we mean is an underlying factual inquiry about sort of what will happen in that foreign legal system, right? So in an asylum case, an immigration judge will often look at what a foreign authoritarian laws say, and if we're talking about claims of forced sterilization, for instance, in the abortion context, in the abortion asylum context, it's certainly the case that a U.S. judge will look at what is law on the books in a foreign country on national family planning, on forced sterilization. But what the judge should care a lot more about is sort of foreign law as evidence of foreign practice, right? Because you can't just look at what the laws say. There aren't that, forced sterilization at the local level in China is often not law on the books. But, if you look at how American judges or agency officials describe what they're doing, they often still couch it in a law-based inquiry as well. So I would say that these issues around hidden laws and sham laws still are quite important in a number of cases too, perhaps not as much in the civil commercial law context, as you point out.
Right. I don't know whether you have time to answer one more question. Although I think that's probably a bit difficult. The question is, are you aware of any takes by U.S. courts on China's latest personal information protection law, which was just promulgated last year? look, before this law was promulgated, China already have some, you know, a lot of data-related laws. So I don't know whether you can share some of your thoughts on how the litigants can use some of the Chinese law to show the discovery in the U.S.
Yeah, so I'm not aware of any cases yet that have come up, and I think if there were some, it might be too soon now, given that it's only 2022 and cases take their time to make their way through in U.S. courts, with some of which are quite slow and quite docket constrained. But this would certainly be quite interesting to look at. But no, I'm unfortunately not aware.
All right, great. Thank you so much, Mark. It's wonderful to have you here, and congratulations on everything that you have achieved, and best of luck to you as you officially embark on your academic career. This is a very important piece of work, and I'm glad that we have the opportunity to hear from you and then and introduce your scholarship to the audience. So thank you all.
Thank you so much.
Thank you, Jack. Thank you. Bye-bye.